This is a summary of the WeMoral 2026 report on how the 27 European Union member states put the whistleblower directive into national law. The report compares all 27 transpositions across 33 dimensions of scope, process, protection, and enforcement. Every figure comes from the national statutes themselves. The law is stated as at July 2026. Directive 2019/1937 set a floor and left the ceiling open. States may protect more than it requires. They may not protect less. Most of the variation in this report sits in the space above that floor. The result is that one European standard exists in outline only. A worker who reports the same wrongdoing in Madrid, in Tallinn, and in Budapest is covered by three materially different laws, and in one of them has no civil remedy at all. For a company operating in more than one member state, a single group procedure written to the directive is not enough. It will be compliant in the states that stayed close to the text and short of the law in the states that went further. The directive gave member states until the 17th of December 2021. 2 met it, Denmark and Sweden, both in force on the deadline day itself. Nobody was early. The remaining 25 arrived over almost 3 years. Poland was last, on the 25th of September 2024, 1,013 days after the deadline. The 50-worker threshold survived almost everywhere. 26 of the 27 billed the private sector duty on it. Lithuania is the exception, with no headcount trigger in the law itself. The counting rules are where scope actually moves. France requires 50 workers at the close of 2 consecutive financial years, so a company that crosses the line for 1 year alone stays outside. Luxembourg requires the number to hold over 12 consecutive months. 12 states set out no counting rule at all. Below the threshold, most states added sectors that are covered at any size. Finance and anti-money laundering entities are the near-universal addition. Italy goes furthest and pulls in every organisation with a 231 compliance model, whatever its size. Slovakia reaches every public authority with 5 employees. Groups are the open question. The directive says nothing about running one channel for a whole corporate group. 8 member states resolved it in the group's favour. The other 19 are silent, and the only express relief there is the 50 to 249 sharing band or outsourcing. Anonymity is the most fragmented dimension in the whole comparison. 3 member states make anonymous intake compulsory, Spain and Portugal in both channels, and Belgium in the private sector above 250 workers. 12 states permit anonymous reports without obliging anyone to accept them, which is the directive's own posture written down. France permits anonymity generally, but makes it mandatory only in the financial sector. 3 states close the door. Bulgaria bars proceedings on an anonymous report and asks for a name and a signature. Latvia has no anonymous route and substitutes mandatory pseudonymization. Malta excludes anonymous reporters from protection. Finland permits anonymous reports internally while its external authority refuses them outright. Acknowledgement is the closest thing to uniformity in the report. 26 member states acknowledge an internal report within 7 days. Lithuania is faster at 2 working days. Greece and France count working days rather than calendar days. Feedback deadlines diverge much more. 3 months is the standard in most states. Croatia sets 30 days with a 90-day maximum. Czechia starts at 30 days and allows 2 extensions. Hungary sets 30 days and forbids anything beyond 3 months. Lithuania is the outlier at 10 working days, with no extension mechanism and no outer limit. Retention is the widest split of all. 11 member states set no period at all and leave the whole decision to the organisation. 16 fixed a number, and the numbers are far apart. Spain sets a ceiling of 10 years. 8 states settled on 5. 4 chose 3. Sweden is at 2 years from closure. Cyprus orders deletion 3 months after closure. An organisation running channels in both Spain and Cyprus needs two separate retention policies for the same category of record. WeMoral is whistleblowing software built for exactly this problem. One platform, with the intake rules, the acknowledgement and feedback clocks, and the retention periods set per country. On what can be reported, almost nobody stopped at the directive's list of EU policy fields. Only Estonia and Greece kept it untouched. Slovenia protects a report about a breach of any regulation in force in the country, and the Netherlands protects a report about any societal wrongdoing, with no link to EU law required at all. On who is protected, the 27 converge more than anywhere else. All of them protect reporters beyond the payroll, and all of them extend protection to facilitators and to people and entities connected with the reporter. Motive is where money enters. Slovakia runs a state reward of up to 50 times the minimum wage. Lithuania grants an uncapped bounty for valuable information and then bars the retaliation remedy entirely where a reward has been paid. Ireland cuts a reporter's compensation by up to 25% where the motive was mixed. France goes the other way and conditions protection on the reporter having received no direct financial reward. Remedies diverge most sharply of all. Cyprus and Italy declare the Retaliatory Act void and order reinstatement on the reporter's request. Estonia and the Netherlands provide no civil remedy at all. Estonia bans retaliation and fines it, so the money goes to the state and none of it to the reporter. Where compensation exists, the ceilings matter. Ireland caps it at 260 weeks of pay. Lithuania caps it at about €3,700, the lowest ceiling in the European Union. One mechanism underpins all of this. Article 21(5) reverses the burden of proof onto the employer. Most states transposed it. Bulgaria and Czechia did not, and Austria, Slovakia, Finland, Portugal, and Spain each qualified it. Generous remedies in those systems are worth less than they look, because a reporter who cannot shift the burden will rarely prove motive. One more point for anyone drafting exit paperwork. Luxembourg has no anti-waiver clause anywhere in its statute, and Slovenia is silent. A settlement term that would be struck down in Dublin or Valletta may well hold in those two. There is often no regulator to answer to. 5 member states built a dedicated supervisor for the internal channel duties. 10 handed the job to a standing regulator. The remaining 12 have no administrative supervisor at all. 6 of those leave it to the courts, and 6 name nobody whatsoever. The external map is just as uneven. France lists 42 competent authorities across 23 subject fields, and Ireland runs 82 prescribed persons. Croatia routes everything through one ombudsman. Fines run the full range. Spain tops the scale at €1 million for a very serious infringement. 10 member states set no quantified fine on an entity at all, and Hungary's Act expressly bars one. There the exposure sits with the responsible individual or with a court-set fine. 19 member states created no criminal offence around whistleblowing at all. 8 did. Cyprus and Poland reach 3 years in prison, and Ireland reaches 2 years on indictment, including for a failure to establish a channel. Luxembourg inverts the pattern. Its criminal provision is aimed only at the reporter, for a knowingly false report, while the employer's exposure stays administrative. The reporter carries risk too. 20 states penalise a knowingly false report. Spain sets the heaviest at €30,001 to €300,000. Ireland can impose up to €100,000 and 2 years. Greece requires imprisonment of at least 2 years. At the other end, Latvia's ceiling is €700, and 7 states impose no sanction on the reporter, treating the loss of protection as the whole consequence. Support for reporters is the thinnest obligation in the directive. Legal aid is named in 18 member states, psychological support in 7. Denmark, Estonia, and Sweden name no support measure at all. Across 33 dimensions and 27 member states, the list of rules that hold everywhere fits in a paragraph. Every member state prohibits retaliation against a person who reports wrongdoing. Everyone extends that protection past the reporter, to the facilitators who help them, and to people and entities connected with them. All 27 provide at least one route to an external authority, and at least one route by which a reporter may go public and keep protection. And none of them conditions protection on the report turning out to be correct. The test everywhere is whether the reporter had reasonable grounds to believe the information was true at the time. Everything else diverges. WeMoral is whistleblowing software for running internal reporting channels under the directive and its national transpositions. It can be used in any of the 27 member states, with the country rules applied per entity. WeMoral researched and published this report because customers kept asking what their own national law requires beyond the directive. The full report, with the country tables and the charts behind these numbers, is available from WeMoral at wemoral.com. One closing note. This is a comparison of published statutes and it is not legal advice. Before acting on any of it, confirm the current position in the relevant member state with qualified local counsel.